Good morning, everybody. Thank you all for joining the unique conversation I have the privilege to chair on the cyber justice in times of pandemic with a very special guest. Countries around the world are facing unprecedented challenges from COVID-19, and the need for transparency, accountability, mostly innovation have rarely been greater. We know that those working in public service and private sector are looking for new ways to fulfill their duties while maintaining good governance and efficiency in delivering services of all sorts, including judicial, as they move their activities online. And time has come for open government leaders and private sector players and innovators to highlight best practices, focusing on practical and essential needs. And key teams guiding their actions have a lot to do with the straightening transparency, accountability, and mostly access to justice. My name is Marie-Claude Gervais. Many of you already know me, and while I'm happy to join you all this morning in this very unique instance to represent the Department of Justice of Canada and to represent the ACT project numerous partners, I'm extremely pleased to host the first conversation of our promising program. This conversation is meant to introduce case studies which contextualize the challenges and contributions of cyber justice within the judicial forum in times of a pandemic. And it is also primarily meant to inspire discussions which will take place later today and tomorrow in sub-thematic workshops. Many of us acknowledge the legitimate existence of concerns about technical problems associated with court video conferencing. And allow me, as a very brief introduction, to share a few thoughts with you. In a recent publication, zooming in on the importance of upholding legal values in virtual trials, Karim Benyaklev, Nicolas Vermez, Sarit Mezari reiterate that the use of video conferencing in court proceedings is not without um, tangible risks, sizable risks, underlining Amy Salizin's findings, who has examined some possible threats. They build on her observations by discussing legal values that ought to be considered when it comes to virtual trials. We all know how immense is the potential for increased access to justice as a result of video conference hearings. The fact is that we cannot embrace such potential without remaining mindful of the fact that there are principles, in addition, of course, to privacy issues, which must be taken into account. Karim and his colleagues identify some of them in accountability, equal access, legal validity. How do online trials cope with these fundamental principles? What can we learn from the more recent virtual trials models? As many of you already know, CLCT, Center for Legal and Court Technology, is very much involved in this area of development. It is a nonprofit research, education, consulting organization that works to improve the administration of justice through the use of technology. It aims to assist all members of the legal profession, courts, government agencies, judges, lawyers. And given the unique circumstances we face today globally and the opportunities provided to use to achieve unexpected goals, CLCT and its team, loyal to its mission, has mobilized as ever to improve legal systems through the appropriate use of technology. And with us this morning, Martin Gruen, currently the owner of Martin E. Gruen Consulting, LLC, and the Deputy Director Emeritus of the Center for Legal and Court Technology, housed at the William and Mary School of Law. During his over 45 years of providing technology solutions to courts and government agencies, Martin has been at the forefront of court technology. He has designed many of the United States' leading examples of technology and hence courtrooms. And recently, his work has included several international landmarks projects. I'll name one, the technology upgrades to the Supreme Court of Nigeria. In addition, he has served on many committees to develop standards for court technology and is recognized as a subject matter expert. Martin, Thank you for having kindly accepted to join me this morning and for sharing with us your thoughts on cyber justice in times of pandemic. Let's begin. We know that our courts in Canada, as in so many other countries, are currently turning to remote communications as a method to ensure and deliver, as much as they can, adequate administration of justice. In Ottawa, our Department of Justice National Litigation Sector, while advising federal judicial instances, have been obviously focusing primarily on the need to fulfill legal requirements. This leads me, however, to wonder if there aren't other considerations which should capture their attention as courts move forward. Would you introduce the subject, Martin, by telling us what, in your view, should they consider besides legal requirements?
Well, there's a lot that needs to be considered. In thinking about this over the weekend and what I was going to say, I thought back to a time when my daughter brought her college friends down for a weekend at our house. And as they were sitting around talking about things that had happened over the last year at college, there seemed to be a theme that went through all of it. The theme was, it sounded like a good idea at the time. I think that's something we really need to consider as we think about going to virtual. Is this an answer? I think undoubtedly we've already reached the point where, yes, we're going to have to consider this for many, many reasons. If we think back to when we started using video, the first video system that I was involved with designing and installing was in 1992. And the purpose of video then was so we didn't have to transport a prisoner from the jail to the courtroom. And everyone in the United States, and I think in Canada and other countries, were, oh, this is great. It saves money. It can do all these wonderful things. A lot of states, one in particular, Hawaii, spent a lot of money installing these systems because Hawaii didn't have a lot of detention centers. So many of the prisoners were in California, which meant a long air flight down for a hearing. So this was a perfect answer. And they installed one company's system and they were working with it. And suddenly they were inundated with appeals because the system design was when the person was speaking, they took over the entire screen. But when they weren't speaking, the detained person could not see the other people in the courtroom. And that violated the right to see their accusers. So literally, after millions of dollars, they had to shut the system down, do a redesign so that that person could meet that. This is what I mean by it sounded like a good idea at the time. As we go through these things, we need to think through, are we meeting all the legal requirements? Are we meeting all the human requirements? And at the end of the day, are we doing it properly with technology? Let me rattle on. If you have questions, please feel free to interrupt. I prefer an informal method than formal. Again, I mentioned we began with first appearance. Then we moved to having witnesses come in. Traditional courts were a bit slow about this, but in the United States, administrative law agencies embraced the idea of video, especially the Social Security Administration. Some years ago, I had the opportunity to work with them. They were doing a lot of cases to try and get rid of a backlog. And the biggest problem with the backlog was we did not have enough judges in some areas, and we had judges sitting around with nothing to do in others. So the answer was video. It sounds simple. The judge sits in their courtroom. They talk to a video computer. At the far end, you have a claimant, and they're a representative. And so this would all work real simply, right? Well, not really. because suddenly we had something come out of the blue. There were complaints that it wasn't fair. It was not proper. One of the biggest things was, of all things, lighting. If the person, either the judge or the claimant, had dark complexion and the lighting wasn't correct, it shadowed their face. So you could not clearly see the person. And people were saying, well, that judge did not do things properly because they couldn't see me clearly. So suddenly we're talking about lighting. Think for a moment, your average courtroom. Is the lighting designed to meet the requirements of a camera? I haven't now analyzed every courtroom in Canada, but I'm willing to bet if I was to say, no, it's not, I would win on that, because the camera sees light slightly different. If you ever have been to courtroom 21 at the Center for Legal Courtroom, we took the McLaughlin courtroom, and some years ago, we changed the lighting. When you stand in that courtroom, a lot of people complain, boy, this is bright. It's a very white light. It's a very clear light. Yeah, that's for the camera, because the camera sees things differently. Years ago, one of the first video recording systems I ever installed in a courtroom, it was a beautiful historic courtroom. We put the cameras in, we did everything correct. And then I got a call, could you come back and fix this thing? Because the judge was sitting there with a blue robe and a blue chair. Well, in the room, they were black, but the camera saw it as blue, and the judge felt that wasn't proper and formal. So my first thought is, when we move forward to this, think of all the possibilities. Let me go back to another example. I'm dealing with a court that is modernizing all 17 of their courtrooms here in Virginia. When we started the project 2 years ago, following the guidelines by the Supreme Court of Virginia, we installed a Polycom video conferencing system with a large screen. And when the judge would talk to the person on the screen, the camera would be aimed at them. When an attorney would say something, the camera would shift and then would see them. Did it work fine for them to meet the requirements? Yeah, they could see this person that's speaking. They could see the courtroom. The camera could back up and they could see the whole well of the courtroom, so that they, if no one was speaking, they could see what's going on. It meant all of those legal requirements for first appearance. It was located right behind the witness stand. Well, along comes the pandemic. Suddenly people are saying, well, we need to do a whole trial. Well, guess what? If someone was sitting on the witness stand in the courtroom, they could not be seen. Instantly, a design to meet one criteria failed another criteria. And so what I'm doing now with the court, fortunately, we had one of those miracles that very seldom happen in our world. The project is coming in way under budget. So we could afford to buy additional cameras, change the connections in order to meet those requirements. So now I can show everyone, because one thing that we have to figure is, when we say virtual trial, number one, what do we mean by virtual trial? Is everyone in the courtroom? Is no one in the courtroom? Are some people in the courtroom? For most of us, we go to something like Zoom where we can see everybody. We're all on the screen. Why? Because we're all in our own location. If I'm sitting in the courtroom and an attorney is in the courtroom, but everyone else is not in the courtroom, do we have camera coverage? Do we have a system that meets that? It's almost as if we need to sit down and say, all right, number one, what are our plans for this? Are we going to have some people in the courtroom? Okay, well, what are the camera angles? If we're going to have no one in the courtroom, that is a different scenario. Can we come up with the answer to every scenario? No. I'll be very honest with you. We're not going to have a perfect solution, no matter how high we try, because if it's one thing I've learned in the years I've worked with the courts, is there is always going to be a what if that comes up. Well, what if we did this? Or what if we did this other thing? I remember another project many years ago. It was an administrative law courtroom. We had set up the cameras. Everything was working perfectly. And then I got a call that none of the camera shots were working anymore. And they're like, well, did someone move the cameras? No, no one touched the cameras. I went in, I found out they changed all the millwork so the tables were moved. You had to move the cameras to meet the new needs. But they were just thinking the cameras were the same. We haven't changed them. So it's think of the whole process. You were going to say something.
Yes, yes, yes. I would not want to interrupt you, Martin. This is extremely instructive and hugely important. I do realize listening to you how far are we from strict legal requirements, those we lawyers could primarily think of at the early stage of contemplating virtual trial. You've really brought us into the world of not only method, but human reaction. I would not have felt how important is to see the physiognomy, the emotions, the proximity. You mentioned the color, all the camera's setting and the challenges associated with those technical components truly have become extremely important. And I understand that you've been able to build on the experience of those previous instances. Um, and I do understand while you're explaining to us how we've moved from first appearance, specific needs associated to that proceeding, to something brutally, highly more complex today, now that we have to respond promptly to the needs of our current situation. And as we move closer to real tangible issues, I assume logically, if I'm following your reasoning, while you also provide examples, the Hawaii example, you may wish to go back. You did mention the US administrative law. Perhaps you could explain to us how, in your view, is suddenly more complex virtual trial from the first appearance to what we're susceptible to be expected to deliver. You may have been made aware that we have experienced in Canada recently the first criminal trial using that kind of platform. There is so much we will need to learn from that, but having in mind what you just shared with us in terms of example to what should this instance require, how complex, what is the level of complexity we're facing?
Well, whenever you design technology, whether it's for video, whether it's for evidence presentation, even an audio system, what I tell people are these are tools. They're tools to be used to help us, not to change our world. So the first step I would say in when you're trying to design a system is what are the legal requirements? I am not an expert on Canadian law, but I think similar much to what we have here in the States. Well, the first area is by constitutional right, I have a right to see my accusers. So that means during a trial, I need to be able to see everyone in one form or other. I tell people, think of it as if you're sitting there. If I'm in the witness stand, I can turn and see the judge. I can turn and see other people. If I'm at the defense table, I have a certain angle of view. I don't have to exactly mimic it, but I need to be able to see those people. But there's more than just seeing my accusers. We're going to show evidence. I'm going to pick on Chesterfield several times because this is one of the issues. When you design a system for first appearance, you're usually not showing documents. So at the detention center, you have a screen and the person could see the person talking. Well, if I want to show a document to that person, most of those systems are not designed to do that because you need either a second screen or you blank the image of the person and show the document, which now violates, go back to number one, I can't see the people in the courtroom when I'm looking at the document. So we have to think, what am I doing in this trial? And then the third area that seems to be a real problem is, with certain exceptions, it's a public trial. How do I do a virtual public trial? Do I advertise it in the newspaper so everyone can tune in? I think most judges and attorneys would say, no, that's a bad idea. This isn't court TV. But we need to think about, are we meeting all those requirements? And I'm sure there are more legal requirements. In the world of CLCT, Fred Lederer is the lawyer, professor, I'm the techie. So he comes up with ideas, I tell him how to answer it, and he shows me what's wrong because it's violating something. But the point I'm getting at is we need to think through, are we meeting all these requirements? Because in our world, if we don't meet one of those requirements, it becomes an appeal. We want to avoid that. Again, go back to my statement of it sounded like a good idea at the time. If we do something and it generates appeals like Hawaii had many years ago in the early 90s, have we really done a good administration of justice? And then the second thing is, once I figured out what I needed to do, what is my environment like? Right now, most of us are sitting in our office, in our home. The backdrop, some people, I'm going to pick on you, Fred. Fred has a backdrop of CLCT's courtroom. No, he's not in the courtroom. I'll give you honesty. But the point is, my house, you can see my office. Well, if we're in court, do we want the judge sitting there in their home office? Or do we want the backdrop to be the courtroom? It's a minor thing, but part of this is, and where I'm heading with all this is, we have to deal with human beings. Sometimes we get so wrapped up, myself with the technology, judges and lawyers with the legal aspects, we forget one thing. We live in an emotional world. We see this where people get upset over things, they react. When that person comes in, they're in court. Very often it's a very emotional thing. It's a very scary thing. At the end of the day, can they said, whether they won or whether they lost, I had my day in court. If we don't do this properly, if I'm here, I'm wearing a tie, shirt, jacket, I'm presenting. Could I not be wearing a t-shirt and shorts? Yeah, I could. But what would be the human reaction to a person when you look at them? Does the judge need to be in a robe and if proper in a wig? If that's what you see in the courtroom, yeah. I mentioned Social Security Administration. Well, when we set up the systems, we actually went and they bought a bunch of picture screens. So when the judge would sit in their office, they pulled down the screen behind them so the camera thought it was a courtroom. Rather than build out an expensive courtroom, we could do this from their chambers, but just simply pull it down, hide the family pictures and the books, and it looked like a judge sitting in court, and just lift the screen up when we're done and we're back in business. It's these little things that will make it important to a person. It's the human element. And then there's the technology. Technology can be a real problem because when we look at this equipment, part of our equation is the industry ready for this? We're all meeting today with Zoom. Zoom can do some amazing things. I can take a Polycom or a Cisco video conferencing system now, and I can connect to Zoom. But does Zoom have certain security issues that could be a problem in our world? What about WebEx? What about Team? All of these wonderful things. And then the answer usually comes back to me, yeah, but those are computer programs. I want real video conferencing. I want a real high definition camera and Cisco codec and all the rest. And the problem is the industry is going through a real hard change. Will these hardware codecs we built our world around be around in a few years? That's a big question mark. Of course, the company wants to sell you a $17,000, $20,000 box, but if a $400 computer running software can do the same thing, what is the purpose of this? So as we plan how we're going to integrate our courtrooms for a cyber world, we need to pull out our crystal balls and say, okay, I'm building this today, but in 5 years, when I need to refresh this hardware, is it still going to be valid? Do we have the answers? No.
No. Indeed, Martin. You're truly helping us identifying several very tangible issues related to what we've been trying to work with. I would have been tempted to share with everybody some rights, one of them to a jury in Canada protected by Section 11F under our Canadian Charter of Rights and Freedoms to illustrate those constitutional rights we should have in mind when introducing ourselves to managing hearings. But from there to another hugely important element is the accuser of the view that he has had is they in court. So you very wisely introduced the human element besides the technical challenges as well. What I'm tempted to ask you at the end is building on our recent experience. Are we ready to transform our practices in delivering trial remotely while at the same time promoting a better access to justice? Are we ready to learn lessons?
Are we ready to learn lessons? I don't think we have a choice. Ready or not, we're going to learn a lot as we move forward. And we're going to make some mistakes. Hopefully not major ones, but we can learn from this. The biggest thing is we need to think all of this through. A project some years ago that we had was with the Administrative Conference of the United States. That is a federal funded agency that creates guidelines and standards for all of the administrative law federal agencies in the United States. I wrote for them, working with a committee, a very boring document. The boring document talked about video conferencing and talked about lighting and temperatures and room colors and cameras, and what was absolutely boring to everyone that was involved as a lawyer or a judge. But for the technologist, for the administrator, these are things that happen. It's little minor things that are common to the broadcast world that we've never thought of. Have you ever thought of the color on the walls in your courtroom? Well, of course not. Why would we worry about the color? To a camera, a white background makes it actually work harder. And as it's working harder, it's taking more bandwidth. And I'm moving us into another area that we have not considered, and that is how much bandwidth do we have in our courthouse? What if we have a 40 courtroom courthouse and we have 40 high definition video conference systems going on at the same time? Do we have enough bandwidth? Because a high definition camera eats a lot of bandwidth. Oh, well, we'll lower the resolution. We'll go down from 1080 to 720. Forget about 4K. We don't have the bandwidth for that. I can tell you that right now. So we lower our resolution. I've made the face a little grainier. I've cut back on some of the resolution. Have I now gone backwards in this? Do I have the answers to tell you if you're ready? No, I don't. Do I encourage you to study this, to analyze all of this? Yes, I do. At the end of the day, as I mentioned before, and it looks like time is running, so I'm going to wrap this, is we don't want to come down 5, 10, 2 years from the future, look back at what we did and say, well, it seemed like a good idea at the time. We want to think this through, look at all the aspects, and then move forward, because I think we don't have a choice. It's not, should we go to this? Should we not go to this? We're going to have to consider a cyber world. We're going to have to consider a virtual courtroom. What we need to do is plan, think it through, and make it work.
Thank you for such a useful and crucial tour d'horizon of where we should stand, as it becomes imperative that we have a closer look at what is available in terms of cyber justice platforms. And as we wonder how could these be improved to remain respectful of our justice system most valued principles. And series of events such as ours today are designed to facilitate conversations around courts' responses to the pandemic and how to move towards open and effective recovery efforts. You and I, our organizations, our governments, we're provided with a unique opportunity to engage and to innovate, and more importantly, to deliver a diversity of proposals, tools, and to put them to test while acknowledging that the resulting practice is perhaps meant to stay. Thank you, Martin, for having shared with us those examples. And this means that while we recognize that virtual trial is key, we have the duty to identify the risk associated with its use, or at minimum, its limitations. We are more likely left with, I guess, one central question: how reliable are the current models in terms of future innovative standards? I thank you all for your attention and hope that this was enlightening, and wish you fruitful discussions later today.